Hello and welcome to our today's lecture on Section 84, 85 and 86 of Indian Penal Code. Insanity under Section 84, intoxication under 85 and 86, a defense to criminal liability. Section 84, Insanity, act of a person of unsound mind. Nothing is an offence which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Insanity as a defense in a criminal prosecution is embodied in Section 84 of the Indian Penal Code. It says that unsoundness of mind is a defense to a criminal charge. Principle: the defense of unsoundness of mind is based on the theory that one who is insane has no mind and hence cannot have the necessary mens rea to commit a crime. Being deprived of free will, a madman is placed in even a worse predicament than a child, because the latter can at least control his will and regulate his conduct, whereas the former cannot. In fact, a madman is punished by his own madness. Moreover, the act of an insane person being unintentional and involuntary, no court can correct him by way of punishment. But at the same time, the society has to be protected against the attack of maniacs. Accordingly, a provision has been made under Section 330 of the Criminal Procedure Code, 1973, for the detention of such persons in lunatic asylums. Unsoundness of mind is commonly termed insanity, and according to medical science, is a disorder of the mind which impairs the mental faculties of man. In other words, insanity is another name for mental abnormality due to various factors and exists in various degrees. Insanity is popularly denoted by idiocy, madness, lunacy, to describe mental derailment, mental disorder, and all other forms of mental abnormality known to medical science. Thus, an uncontrollable impulse driving a man to kill or wound would come within the scope of medical definition of insanity. However, the legal concept of insanity markedly from the medical concept. Insanity in law means a disorder of the mind which impairs the cognitive faculty, that is, the reasoning capacity of a man, to such an extent as to render from him incapable of understanding the consequences of his actions. Hence, it's only insanity of a particular or appropriate kind which is regarded as insanity in law and which will excuse a man from criminal liability. Test of insanity. The important questions that arise regarding insanity are: how is it to be detected, and what should be the demarcating line between sanity and insanity in order to extend to a man the protection of law from criminal prosecution? A number of tests have been given from time to time for this purpose. For example, wild beast test in R versus Arnold, insane delusion test in Hadfield case, counting 20 pence test, good evil test, and so on. But courts definitely formulated tests in very clear terms in M. Norton case, 10 Clark and Finley, which are better known as M. Norton rules. In this case, the accused, Daniel M. Norton, was charged for the murder of Edward Drummond, secretary to then Prime Minister Sir Robert Peel, on January 20, 1843. The accused was suffering from an insane delusion that Sir Robert Peel had injured him, and he mistook Drummond for Sir Robert. Accordingly, he shot and killed him. The accused pleaded not guilty on the ground of insanity. The accused pleaded insanity in his defense, and medical evidence produced showed that he was laboring under a morbid delusion, because of which he lost his power of control. The accused was acquitted on the ground of insanity. His acquittal caused much sensation and became the subject matter of debate in the House of Lords. The House of Lords therefore referred the matter to a bench of 15 judges who were called upon to lay down the law relating to criminal responsibility in case of lunacy. The questions and answers are known as M. Norton rules, which form the basis of the modern law on insanity. These can be summed up as: number 1, every man is presumed to be sane and to possess a sufficient degree of reason to be responsible for his crimes until the contrary be proved to the satisfaction of a jury. Number 2, to establish a defense on the ground of insanity, it must be clearly shown that at the time of committing the act, the party accused was laboring under such a defect of reason, from disease of mind, as not to know the nature and the quality of the act he was doing, or if he did know this, not to know that what he was doing was wrong morally. Number 3, as to his knowledge of wrongfulness of the act, the judges said, if the accused was conscious that the act was one which he ought not to do, and if that act was at the time contrary to the law of land, he is punishable. Number 4, where a criminal act is committed by a man under some insane delusion as to the surrounding facts which conceal from him the true nature of the act he is doing, he will be under same degree of responsibility as if the facts had been as he imagined them to be. He may, for instance, kill under the imagination either that he is an executor lawfully carrying out a judicial sentence, or on the other hand merely that the person killed had once cheated him at cards. Number 4, ingredients. It may be observed that the Indian law on insanity as contained in section 84 of Indian Penal Code is based on the propositions laid down in M. Norton's case. In order to get the benefit under section 84, the following conditions must be fulfilled. Number 1, act must be done by a person of unsound mind. Number 2, such person must be incapable of knowing the nature of the act, or that the act was contrary to law, or that the act was wrong. Number 3, such incapacity must be by reason of unsoundness of mind of the offender. Number 4, the incapacity of the nature stated above must exist at the time of doing of act constituting the offence. Act must be done by a person of unsound mind. Before an accused is entitled to the benefit of section 84 Indian Penal Code, he must establish that at the time of committing the act he was non-compo mentis, which is not of sound mind. If he does not succeed in this preliminary issue, the plea must fail. Such person must be incapable of knowing the nature of the act, on that the act was contrary to law, or that the act was wrong. Even if the accused is of sound mind, he must prove that the said unsoundness of mind was of a degree and nature to fulfill the tests as laid down in this section. He must prove that at the time of committing the offence, he was laboring under a defect of reason which had been caused by unsoundness of mind, with the result that he was rendered incapable of knowing the nature of the act, and that he was being what was either wrong or contrary to law. The incapacity of the nature stated above must exist at the time of doing of the act constituting the offence. The third ingredient for the applicability of this section is for the accused to prove that he was insane at the time when he has committed the act, and not merely before and after the act. The proof of the insanity of the accused at the nick of the time is highly improbable. His insanity at the time of occurrence has to be judged from his conduct at the time of occurrence along with other attendant circumstances. Principles to be considered while dealing with insanity. In dealing with insanity, a number of principles in this connection have to be borne in mind. Number 1, every type of insanity recognized is no legal insanity unless the cognitive facility of mind is destroyed as a result of unsoundness to such an extent as to render one incapable of knowing the nature of his act, or what he was doing is wrong or contrary to law. Number 2, the court shall presume absence of insanity. Number 3, the burden of proof of insanity is on the accused. Number 4, every minor mental aberration is not insanity, and circumstances indicating a mere possibility of legal insanity cannot, however, be sufficient to discharge the onus resting on the accused. Number 5, to attract the immunity provided in Section 84 of the Indian Penal Code, the court has to consider whether the accused suffered from legal insanity at the time when the offence was committed. In reaching this conclusion, the circumstances which preceded, attended, and followed the crime are relevant considerations, and when a plea of insanity is raised, it is not the duty of the prosecution to establish affirmatively that the accused was capable of knowing the nature of the act or knowing that what he was doing was either wrong or contrary to law. Every person is presumed to know the law and the natural consequences of his act. The prosecution, in discharging its burden in the face of the plea of insanity, has merely to prove the basic fact and rely upon the basic presumptions aforesaid. It is then that the accused is called upon to rebut these presumptions and the inferences in such manner as would go to establish his plea. Bebya Chhaganbhai Thakkar versus State of Gujarat, 1964. It was observed that when a plea of legal insanity is set up, the court has to consider whether at the time of commission of the offence, the accused, by reason of unsoundness of mind, was incapable of knowing the nature of the act, or that what he was doing was either wrong or contrary to law. The crucial point of time for ascertaining the state mind of accused is the time when the offence was committed. Whether the accused was in such a state of mind as to be entitled to the benefit of Section 84 of the Indian Penal Code can only be established from the circumstances which preceded, attended, and followed the crime. State of Maharastra versus Umesh Krishna Pawar, 1994. The accused took her to a lonely place, and after committing the offence and after sexually assaulting the young girl, the accused also not merely ran away, but he took the precaution of lifting the body and throwing it into a canal with the obvious reason of screening off the evidence of the consequences of this act. It was held that it was a carefully thought out and manipulated action, and certainly not the act of an insane human being. Therefore, the defense of insanity was rejected. Srikant Bhosle versus State of Maharashtra, 2003. The accused hit a stone on the head of his wife who was washing clothes, and she was killed. He pleaded insanity in his defense, which was rejected by the trial court and the Bombay High Court. On appeal to the Apex Court, he contended that he was entitled to the benefit of Section 84 as he, at the time of killing his wife, was insane. He produced medical evidence and testimony of 2 medical specialists who stated that the accused suffered from suspicious ideas, persecutory delusions, loss of sleep, and was a paranoid schizophrenic. There was history of psychiatric illness in his family. Relying on this evidence, the court allowed him the defense of insanity. Burden of proof. The doctrine of burden of proof in the context of insanity may be stated: Number 1, the prosecution must prove beyond reasonable doubt that the accused had committed the offence with the requisite mens rea, and the burden of proving that always rests on the prosecution from beginning to the end of the trial. There is a rebuttable presumption that the accused was not insane when he committed the crime in the sense laid down by Section 84 of the Penal Code. The accused may rebut it by placing before the court all the relevant evidence, but the burden of proof upon him is no higher than that rests upon a party to civil proceedings. Even if the accused was not able to establish conclusively that he was insane at the time he committed the offence, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the courts as regards one or more of the ingredients of the offence, including mens rea of the accused, and in that case the court would be entitled to acquit the accused on the ground that general burden of proof resting on the prosecution was not discharged. It is fundamental principle of criminal jurisprudence that an accused is presumed to be innocent, and therefore the burden lays on the prosecution to prove the guilt of the accused beyond reasonable doubt. The prosecution in a case of homicide has to prove beyond reasonable doubt that the accused caused the death with the requisite intention, described in Section 299 of the Penal Code. The general burden never shifts, but under Section 105 of Evidence Act, the burden of proving the existence of circumstances bringing the case within the exception lies on the accused, and the court shall presume the absence of such circumstances. Section 85. Intoxication. Section 85. Act of a person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by a person who, at the time of doing it, is by reason of intoxication incapable of knowing the nature of the act or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. Section 85 and 86 lay down the law relating to intoxication or drunkenness as a defense or plea in mitigation of criminal offense. Section 85 as a defense is available to a person who is by reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered without his knowledge or his will. Since criminal intuition is the foundation of all criminal responsibility, it follows that a person who is drunk is in the same predicament as a person who is temporarily insane. Indeed, such a state has been termed dementia affectata, a form of lunacy in which the functions of the mind are temporarily suspended. But since no man can be permitted to wear the cloak of immunity by getting drunk, the rule justly accepts cases of voluntary drunkenness. Ingredients. In order to claim exemption from criminal liability under Section 85, the accused has to establish that at the time of doing the criminal act, when a person is under a state of intoxication, at the time of doing something as a result of which he does not know the nature of his act, or that what he is doing is wrong and contrary to law, he will not be guilty of the same. If this thing which intoxicated him was administered to him without his consent and against his will, the defense is not limited to drunkenness only, but extends to intoxicants as well. Evidence of intoxication, therefore, is admissible for the purpose of ascertaining whether he was incapable of entertaining the specific intent changed, where such intent under the law is an essential ingredient of the particular crime alleged to have been committed. That the thing which intoxicated him was administered to him without his knowledge and against his will. The expression without his knowledge used in Section 85 denotes that it should be totally involuntary intoxication, meaning thereby that the person concerned should be ignorant of the fact that what is being consumed by him is an intoxicant or mixed with intoxicant. That is to say, he should be completely unaware of the fact that whatever is being administered or given to him has an intoxicating effect. The expression against his will implies that the person was coerced or forced to consume an intoxicant, or he was administered that intoxicant by fraud or deceit. If a person consumes an intoxicant or a drink on normal precaution or actuated to keep the company of his friends to enjoy the drink, it would not be said that he consumed it against his will, unless there is an element of compulsion exercised on him. The Director, Public Prosecution versus Beard, 1920. In this, the leading case on the point, the accused raped a girl of 13 years of age and thereafter put his hand upon her mouth and his thumb upon her throat in a bid to prevent her from screaming, and caused her death by suffocation. On being charged of murder, the accused pleaded drunkenness in his defense. Rejecting his plea, he was held guilty of murdering in view of his successive acts of rape, followed by the use of violence causing suffocation, which could not be regarded independent of each other. Basdev versus State of Pepsu 1956 provides a good illustration of intoxication as a defense in criminal law. In this case, accused, a retired army officer, was charged of murder of a young boy aged 15 years. Both of them, along with others from the village, attended a marriage and then went to the bride's house for taking lunch. While taking the seat, the army officer, who was dead drunk, asked the boy to move a little aside so that he could occupy a convenient seat. But the boy did not move. Hence, the accused took out his pistol and shot the boy. The injury proved fatal and the boy died. The evidence on record showed that though the drunken accused was coherent in his talk, but he was capable of walking independently. The facts that he came on his own to the bride's house, made a choice of his seat after firing at the deceased, and attempted to get away from the scene of crime and took shelter at a short distance sufficiently prove that he knew that what he did was an offense and contrary to law. Therefore, his conviction and sentence for the offense of murder did not warrant any interference by the count. Section 86. Offense requiring a particular intent or knowledge committed by one who is intoxicated. In cases where an act done is not an offense unless done with particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge and against his will. The law relating to voluntary drunkenness is contained in Section 86 of the Code. A person voluntarily intoxicated will be deemed to have the same knowledge as he would have had if had not been intoxicated. This section does not say that the accused shall be liable to be dealt with as if he had the same intention as might have been if he had not been intoxicated. There is definitely a presumption so far as knowledge is concerned, although there is no such to constitute them. Drunkenness was never an excuse for criminal misconduct, and indeed, the classic authorities broadly assail that voluntary drunkenness must be considered rather an aggravation than a defense. It is said that a man must know the natural consequences of his act, and if he knows what the consequences are likely to be, he must be held to have intended them. The inference from knowledge to intention would not arise when a man is drunk. Voluntary drunkenness under Section 86 does not afford a defense where merely knowledge required constituting an offense was wanting, though it may be used to show that any intent, if required, was absent. That is, he can only be punished on the basis of knowledge and not of any particular intention. Ingredients. Section 86 deals with that class of cases wherein a man enters into intoxication voluntarily. It imputes the same knowledge to such a man as he would have had he not been intoxicated. For example, if a man who has consumed too much liquor takes a knife from his house and goes along the road shouting his intention to kill B, with whom he had quarreled earlier, and kills C, who tries to pacify him, A would be imputed with the same knowledge as he would have had he been sober, and his act would amount to culpable homicide punishable under Section 304 IPC and not murder. The presumption that a man intended the natural consequences of his acts might be rebutted in the case of drunkenness by showing that his mind was so affected by the drink that he had taken that he was incapable of knowing that what he was doing was dangerous. The law of drunkenness has been very nicely summarized in Basdev versus State of Pepsu 1956. Supreme Court laid down these rules of guidance. Number 1. The absence of understanding of the nature and consequences of an act, whether produced by drunkenness or otherwise, is a defense to the crime charged. Number 2. The evidence of drunkenness which renders the accused incapable of forming the specific intent essential to constitute the crime should be taken into consideration with other proved facts in order to determine whether or not he had this intention. Number 3. the evidence of drunkenness falling short of a proved incapacity in the accused to form the intent necessary to constitute the crime, and merely establishing that his mind was affected by drink so that he more readily gave way to some violent passion, does not rebut the presumption that a man intends the natural consequences of his acts. Dasa Kanda versus State of Orissa, 1976. The plea of the accused appellant that under the influence of liquor he could not have formed the requisite intent for committing the murder of the deceased, and hence that his offence be treated as culpable homicide and not murder, was not sustained. It was held that the normal presumption is that a man intends the natural consequences of his act unless rebutted by the accused by giving such evidence of drunkenness as might have affected his faculty of understanding to form the requisite intent. In the instant case, the plea could not be upheld because of the clear and cogent prosecution evidence which established the guilt of the accused. Sarthi versus State of Madhya Pradesh, 1976. 3 drunken accused persons had overpowered the deceased and rendered him unconscious by rough handling. They had thus the specific intent to cause grievous hurt until then, but the question with regard to the intent became dubious until when the accused persons hanged him from the ceiling without taking steps to ascertain whether he was dead or alive. With this, we come to the end of today's lecture on Section 84, 85 and 86 of the Indian Penal Code. Hope you enjoyed it, and thank you for watching.